I'm ready when you are.
Good afternoon.
Hey, let me ask you a question. So why do you not already have the Huffman case?
It's not in my, like, I didn't get it to approve after you signed. I have the other three, and then we're still waiting on Cooley's. But I didn't get Huffman.
Yeah, it looks like it says it's error.
Did he have Huffman? Did I follow?
No, let me see right here. I've got it. Tapped it. It said
Yeah, it says very.
error. Sorry, what's this?
Can't get anything back.
Okay, that's fine. Resend it. It says processing. It says it's sent, but that's what we said last time too. So you double check it.
Okay.
Is it okay about you think, Judge?
Is that your client?
It may be.
That one's gonna be locked. Go through that back one, and you can just kind of leave it open. All right, Mr. Manning, who are you ready on?
Yeah, we start with Mr. Cunningham.
All right, it's cause number CR 25-94, State versus Jeremy Quinn Cunningham for arraignment.
Yes, Judge. Before we begin arraignment, Mr. Cunningham let me know 2 minutes ago that he would like to retain a lawyer, and he wishes to have a retained lawyer represent him in this case.
Mr. Cunningham, why did you request court-appointed attorney if you intended to hire your own attorney all along?
Well, at that time, you know what I'm saying, I was out there, I was working and stuff, then parole, they put a blue one out for me. So I was gonna be able to have the money, you know what I'm saying, but then they arrested me after that, after I come to court for you. So my mom gonna put the money down, you know what I'm saying? And they ain't hit me with a 5 to 99, so my family feels like I should have a good lawyer. I'm not saying he's not a good lawyer, but somebody that's gonna fight and fight, you know what I'm saying? It's 5 to 99. That's my life, you know.
So you're going to hire an attorney to represent you in this crime, which this allegation of a crime, which is a second-degree felony offense of possession of controlled substance. Let's go ahead and arraign him today, Mr. Manning.
And Judge, on that, I believe that Mr. Cunningham has been previously arraigned in court last time. He came into my office after court last time. We went over discovery. So I think we may have arraigned him last time. I actually was confused by that, but Mr. Cunningham and I talked this morning, and he said he was arraigned at our last court setting.
Okay, it does say set for pretrial also. Let's see.
And Judge, if we need to arraign him, I can do that. Step in for whoever he chooses to retain for that purposes of arraignment.
Let's go ahead and arraign him. I think what happened last time was in court on June 10th. You were not here. I think I appointed you as counsel since I was setting it for August. And that was back on June 10th, that I didn't want to waste time, so I set it for both arraignment and pretrial. So I doubt that he's been arraigned.
I don't recall, but like I said, my client said that he was, so I'm relying on that.
Yeah, I'm not gonna rely on that. I don't think he has. I mean, this is your first appearance with him. You weren't in court with him in June, and there's no waiver. So,
Yes, Judge, I did meet with him in my office though. So I assumed that by that we must have done arraignment previously.
okay.
But if we want to, if you pull up the copy of the indictment, I can go over that again with him.
Can you see it now?
Yes, Judge. Okay, so as we talked about at my office, secondary felony enhanced to first degree fatal punishment, it's 599 in life. You've been charged with methamphetamine more than 4 grams, but less than 200 grams. Of an offense date of February 12th, 2025. The enhancement paragraph. Judge, would you mind scrolling down just a little bit? The enhancement paragraph comes out of Smith County from November 28th, 2022 for offensive burglary of habitation. If they prove that it's true, and the punishment, as I said, goes from that 7-degree felony up to first degree felony. If they prove what is true. If they prove what's true. If you were previously convicted. Yeah, I went to prison. Yeah, we don't need to tell them. Oh, right. They have to prove it. Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty to this offense and the enhancement this time.
All right, the court's going to enter Mr. Cunningham's plea of not guilty into the record. Finds that he's waived the formal requirements of arraignment. Court is going to set Mr. Cunningham for pretrial. We'll set him on Thursday, September 18th. Mr. Cunningham, if you want to hire an attorney, you have the right to do so. You should do so and have that attorney file a motion to substitute counsel. If your attorney does that, then the court will grant that and I will relieve Mr. Manning. But until then, I'm not going to stop the progress of this case, because if you don't hold up your end of the bargain, then it would be an unnecessary delay. So we're going to continue as if Mr. Manning is going to represent you throughout the entire case, as you requested the court to appoint an attorney, and the court's done so. Hire your attorney, file a motion to sub. The attorney will know what to do.
So yeah.
Mr. Hawkins, was that your client out there?
It is, Your Honor. He's meeting with Will right now on the probation department.
Okay.
It was sentenced.
Who's next, Mr. Manning?
Judge, next we have Mr. Odell.
Vincent Everett Odell, CR 25170.
Judge, I have had a copy of the indictment provided. I believe this is a recent appointment as of today. And I went over that copy of the indictment. Mr. Odell's name is spelled correctly. He understands the charge against him. Pleads not guilty and requests to be set on the pretrial docket.
All right, the court enters Mr. Odell's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. The court will set him for pretrial hearing September 18th at 9 a.m.
Thank you, Judge. Judge, is that 1:30?
1:30. I'm sorry, I said 9 a.m. 1:30.
Judge, next ready on Mr. Baird.
This is cause number CR 25-153, CR 25-164, State of Texas versus Walter Lynn Baird for arraignment. Go ahead, Mr. Manning.
Judge, Mr. Bear's name is spelled correctly. He understands the charges against him, pleads not guilty in both cases, and requests to be set for pretrial on both cases.
All right, the court enters Mr. Bear's plea of not guilty into the record on each case, finds that he's waived the formal requirements of arraignment, and the court sets pretrial September 18th at 1:30.
Thank you, Judge. Next, we have Mr. Hughes.
CR 25-79, State of Texas versus Brian William Hughes for docket law. Go ahead, Mr. Bennett.
Judge, Mr. Hughes, his case is dependent on some dispository issues that are by a co-defendant and are of civil nature. And so at this point in time, we've been unable to get a definitive idea of when those cases are going to be resolved. Mr. Hughes has business in another county, and so what the state has agreed to is give him a PR bond. And I also asked to set him for a jury selection, so that he can get in line for a trial if it is necessary.
What's the purpose of the PR bond?
Further investigation for the DA's office and for him to go take care of his business in, how was it? In Dallas County.
And Your Honor, just to clarify, the property that is at issue here is currently under probate. So State's point in the PR bond is obviously if either co-defendant had rights to that property, you can destroy your own property, you can demolish your own property. So it wouldn't be a crime. So State's point in the PR bond is probate can take some time. Obviously, we don't know how much time that's going to take, but if it would be an absolute defense, and State doesn't see a point in Mr. Hughes having to wait for potentially a year or two while that probate matter is carried out.
So what I'm hearing you say is that a probate court is going to determine whether or not Mr. Hughes had a right of ownership to the property that the state's indicted him of destroying.
That's my understanding, Your Honor. I apologize. Offhand, I can't remember which of these two co-defendants may have a possessory interest in the property. But my understanding is one of them may, but it hasn't been determined yet.
And Judge, I apologize. You were speaking, but we weren't hearing anything on our end, so not sure what the question was.
I posed the question of whether the state's position was that a probate court was going to decide whether or not Mr. Hughes had a property interest in the property that he's accused of destroying. Here's my concern. I don't want this case to be sitting on my docket for 1 to 2 years if that's how long it's going to take for probate. If there's an issue with ownership, the state could just dismiss the case and let that probate decision be made, and then state could act accordingly. But I'm not going, I mean, most of our trials are not even taking a year to get to. So I definitely don't, and both of you, if you're not aware, OCA new law was passed, and judges are under strict reporting requirements and for resolving cases quickly. And so it would be in violation of that new Senate bill for me to give a personal bond and then just let it ride the docket for 1 to 2 years, waiting on another court to decide a legal interest that I think the state and the defense could have an opinion on at this time.
Well, Judge, I have an opinion. The state doesn't share that opinion. And so all I'm looking out for is Mr. Hughes's interest as he's being detained here in Van Zandt County Jail. He's waited patiently as the case has moved through its paces. He's been patient as I've negotiated with the state as well as with the code, seeking to get assistance from the co-defendant. And that hasn't resulted in dispositive direction at this point.
And I'm not saying that I wouldn't grant a personal bond, but what I am telling you is I'm not going to grant a personal bond and let it ride the docket for 1 to 2 years. That's not going to happen.
And-
I'm going to set it for docket call in 30 days, and we're going to make decisions, or we're going to set it in 60 days, and state's got to make a decision whether it's going to go forward or not.
And Your Honor, state would be ready for trial. I think it's more of a matter of all defenses being available to Mr. Hughes. If he's ready to get on the trial docket now, and that defense may or may not become available by the time we get to trial, I just wanted to make sure that everything is clear before we go and set him for trial docket.
Okay, I'm not sure we're all on the same page, but I understand what you're saying. So, does Mr. Hughes have any other criminal history or any other issues that the court needs to take into consideration before granting any kind of bail reduction under 17-151? Those are requirements that the court has to consider.
Judge,
I'm pulling that up now, but if Mr. Manning has ready information, I'll defer to him.
I was going to say, Judge, it's been so long since I spoke to Mr. Hughes about his criminal history. I wouldn't be able to accurately reflect that.
Quick summary, Your Honor, and these aren't always 100% accurate, but I see a misdemeanor criminal trespass and a couple of misdemeanor thefts. They're usually pretty accurate on the summaries, but not always 100%.
Okay. All right, the court will review the criminal history in the PSRS system as I'm mandated to do. So how far out do you want me to set this case?
Judge, I imagine with him being in Dallas County, he's going to have to at least have a little time to get there and get his business resolved. We want to set it for 45 days, 60 days. And I can provide information to the court if he's still in custody, provide information about the status of his case once I get in touch with his lawyer over there.
So will he be going in custody from Van Zandt to Dallas?
Yes, Judge.
And he understands the inherent risk that should he later be found legally criminally liable for this offense, he will not get credit for any time that he is in custody elsewhere while he is on a personal bond in Van Zandt County?
Yes, Judge, I've explained that to him. That's part of the reason why we waited so long with him being in custody here in Van Zandt County.
Okay. All right, court will set Mr. Hughes then for October 16th for docket call, and the court will entertain the recommendation from the defense and the state to give Mr. Hughes a personal bond.
Thank you, Judge. I'll have the order over this afternoon.
Who's next?
Ready on Mr. Paul Richardson.
Mr. Richardson, if you'll come forward. This is cause number CR 25-171, State versus Paul Rodney Richardson for arraignment.
Yes, Judge. Mr. Richardson's name is spelled correctly. He understands the charge against him as well as the range of punishment. For request to be set on the pretrial docket. His plea is not guilty.
All right, the court finding that Mr. Richardson, having waived the formal requirements of arraignment, enters his plea of not guilty into the record and sets this matter for hearing for pretrial on September 18th. Is that enough time, Mr. Manning?
Yes, Judge.
September 18th at 1:30.
Judge, next ready on Mr. Templeton.
Stephen Marcus Templeton, CR 25-115, is this, and also CR 25-116, is this a plea?
Judge, we were in anticipation for Mr. Templeton arriving here from TDC. I went ahead and had them prepare the paperwork for what we negotiated. It wasn't quite where my client and I had landed. I didn't have a chance to talk to him before today, so I had them prepare that paperwork. He's asked for a reset to take a look at some issues, potential issues in one of the cases. So if we would reset to pretrial, I can waive arraignment if you'd like.
Well, let's just arraign him today and we'll set it for pretrial. That way you
Okay.
don't have to file the waiver.
Judge, his name is spelled correctly. He understands the charges against him as well as the range of punishment. His plea is not guilty and he asked to be set on the pretrial docket.
All right, the court finding Mr. Templeton having waived the formal requirements of arraignment enters his plea of not guilty into the record in each case respectively and sets the matters for pretrial hearing September 18th at 1:30 in each case.
Next, ready on Mr. Warrington.
On who?
Warrington, William Warrington.
William Gerald Warrington, CR 25-138 for arraignment. Go ahead.
Yes, Judge. His name is spelled correctly. He understands the charge against him as well as the range of punishment. Please not guilty and request to be set on the pretrial docket.
All right, the court enters Mr. Warrington's plea of not guilty into the record, sets this case for pretrial hearing on September 18th, 1:30.
Thank you, Your Honor.
You're welcome, sir.
Yes, Judge. Last reset for the males is Junior Spence.
Junior Lee Spence, CR 25-103. Go ahead.
Judge, Mr. Spence's name is spelled correctly. He understands the charge against him as well as the range of punishment. Request to be set on the pretrial docket. Oh, and his plea is not guilty.
Court finds that Mr. Spence, waiving the formal requirements of arraignment, enters his plea of not guilty into the record, sets this matter for pretrial hearing on September 18th.
Judge, ready on Miss Nix.
Caitlin Shira Nix, CR 25-127 for pretrial.
Judge, I've provided the state some information during pretrial negotiations that we're waiting for a response on. I'd ask for additional pretrial in this matter.
Any objection from the state?
None from the state, Your Honor.
All right, court grants an additional pretrial September 18th at 1:30.
And finally, resets Judge Miss Dorothy Harvey.
All right, Ms. Harvey, CR 25-132, State versus Dorothy Louise Harvey for arraignment.
Judge, I have not had an opportunity to look over the indictment. If we could pull that up. Don't say that. What she did. It's right. It's that before official comments. On April 17, 2025, pleaded guilty to assault and violence. So, is your name spelled correctly? Dorothy Louisa. Where? Right. Right there.
Yeah.
Judge, Ms. Harvey's name is spelled correctly. She understands the charge against her as well as the range of punishment. The plea is not guilty and should request to be set on the pretrial docket.
All right, the court enters Ms. Harvey's plea of not guilty into the record, finds that she's waived the formal requirements of arraignment. Court sets Ms. Harvey for pretrial hearing September 18th at 1:30.
My tomorrow. Judge, there was some corrections that need to be made on Mr. Jones' paperwork. So if I may have a couple minutes to get that sorted out, we should have that played here in just a moment.
Yes, sir. Sounds good.
Thank you, Judge.
Mr. Hawkins, if you and your client want to come up. Yes, Judge. Thank you. All right, court is calling cause number CR 25-143, CR 25-144, State of Texas versus Christopher Roy Carroll. Court finds that Mr. Carroll is set for arraignment today on manufacture and delivery of a controlled substance in penalty group 1 greater than 200 grams, less than 400 grams, and also unlawful possession of firearm by a felon. Mr. Hawkins, are you ready for arraignment?
We are, Your Honor. And Your Honor, on the indictment, my client's name is spelled correctly. He is aware of the nature of the charge, he's also aware of the range of punishment as to each charge, and we plead not guilty in each one of those. And I believe we've asked Judge for the pretrial to be set on the 16th, I think at 1:30, I believe is what and I did file, Judge, just for the court's notice, I did refile my waivers of arraignment, so they are pending in the courts, or at least in the e-file system for today. I did get those files, so they are there.
All right, then the court finding that Mr. Carroll, having waived the formal requirements of arraignment, that his name is spelled correctly, that he understands charges against him and the ranges of punishment. Court enters his plea of not guilty into the record, and the court will set this for pretrial hearing on September 16th at 9 a.m.
Is it 9 a.m., Judge, or?
1:30 is reserved for the
Okay,
afternoon pleas in the jail.
yes, sir.
Someone going into custody.
I got you.
Can you be here on the 16th at 9 a.m.?
We'll be there, Judge.
And court notes for the record that Mr. Carroll has signed his conditions of pretrial release with Mr. West.
Thank you, Judge.
All right, once he signs his notice of appearance, he gets the yellow one, white stays here, and he's free to go.
Yes, Your Honor.
Yes. All right, we'll stand in recess until the court is ready.
we get on that, maybe.
Your Honor, we're ready.
I'm gonna try to keep working on it. We can't get that bill on the wall.
Who are we ready on?
Ready, Mr. Jones?
All right, Mr. Jones, come on up. All right, this is cause numbers CR 24167, CR 24274. State of Texas versus Dennis Ray Jones. Mr. Jones, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your, give me just one moment. Let me see your paperwork. Sorry, I'm having a technical difficulty. The papers are not loading up for me. All right, Mr. Jones. Are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Oh.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Yes.
Sir, do you understand everything that you have read and signed that's part of your case and your paperwork?
Yes.
Do you have any questions about anything before we go further?
No.
Mr. Manning, do you believe Mr. Jones to be competent, and if so, that he understands his rights regarding this case?
Judge, he is competent. I do believe he understands his rights and is willingly and intentionally waiving those rights.
All right, Mr. Jones, I see in cause number CR 24-274, you're charged by indictment with evading arrest or detention with a previous conviction, state jail felony. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in prison and a fine not to exceed $10,000. I see that there is a plea agreement in your case. Upon you pleading guilty, the state's recommending that well, let me take that back. You were originally indicted with evading arrest or detention with a vehicle, a third-degree felony with a punishment range of not less than 2 years or more than 10 years in prison. And the plea agreement today and recommendation is for you to plead guilty to a lesser included offense, that being evading arrest or detention with a previous conviction, a state jail felony. It appears the recommendation from DA's office is upon you pleading guilty, that punishment would be assessed at 315 days confinement in the Texas Department of Criminal Justice State Jail Division. Is that correct?
Yes, Judge.
Along with a $1,000 fine, and I'm sorry, I'm having to read this off my phone, so it's a little bit harder. And also the DA's office would be dismissing unlawful possession of firearm by a felon, which is your other indicted cause, CR 24167. Mr. Manning, how much credit time would Mr. Jones be receiving?
315 days, Judge.
Mr. Jones, part of the plea agreement, you would also be responsible for court cost of $290. And Mr. Manning, is there no reimbursement fees to Mr. Jones for court-appointed counsel?
Judge, because he was taking a state jail sentence, I don't believe there were.
Okay, so this is not a 1244A.
No, Judge, we requested that the DA's office was not comfortable doing that.
Okay, and your client understands he may still have to be sent to TDCJ to be processed in and processed out?
Yes, Judge.
So that means he may not be released today, even though he has served his entire sentence.
We have discussed that. He is aware of that, Judge.
Very well. Okay. All right. So, Mr. Jones, you understand the plea agreement in this case?
Yes, sir.
All right. Then I would ask you, how do you plead to evading arrest or detention with a previous conviction?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right. Then the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered, Judge.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Judge, I just point out that on the judgment, it says that they're dismissing the unlawful possession of firearm by a felon under 1245. However, that is incorrect. It is a straight dismissal. There is not a 1245 agreement, but there is a dismissal that has been executed. So there's a little bit of discrepancy there, but other than that, everything else was correct.
All right, and the court does note that it has been tendered a motion to dismiss and not an adjudication of guilt under section 1245. All right, the court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. Court will follow the plea agreement today. The court assesses punishment by convicting Mr. Jones of evading arrest or detention with a previous conviction, a state jail felony. Assesses his punishment at 315 days confinement in the state jail division of TDC. Court awards him credit for 315 days. The court assesses a $1,000 fine, court costs in the amount of $290, and reimbursement fees in the amount of $20. In addition, the court does dismiss cause number CR 24167, unlawful possession of a firearm by a felon. Mr. Jones, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Mr. Manning, give me just a moment to sign these
Yes, Judge.
forms.
We lost y'all.
You You got me now?
Yes, sir.
All right, Mr. Manning, who's next?
Judge, next ready on Mr. Wade Matthysse.
All right, court calls cause number CR 19182, State of Texas versus Wade Glenn Matthysse. Mr. Matthysse, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can lower your hand. All right, Mr. Matthysse, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
You're represented by your attorney, Mr. Manning. Are you pleased with the work that he's done for you?
Yes.
Do you have any questions about any of the paperwork or anything that you've read and signed today? No?
No, sir.
Mr. Manning, do you believe Mr. Matthysse to be competent? And if so, have you explained to him his rights regarding this case? And is he entering into this agreement intentionally, knowingly, and voluntarily?
Judge, he is competent. I believe he's entering this plea intentionally, knowingly, and voluntarily.
All right, Mr. Matthysse, you are charged by indictment with a third-degree felony offense of tampering or fabricating physical evidence, a third-degree felony. That does carry a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court assess your punishment at 4 years confinement in prison, a $1,500 fine, $180 in restitution, and $290 in court costs. And the state would be asking the court to dismiss indicted cause number CR 19183, which is a possession of controlled substance between 4 grams and 200 grams. Mr. Manning, I do see an issue on the judgment concerning credit time. There's no, how much credit time would Mr. Matthysse be entitled to?
1,293 days.
1293?
That's correct, Judge.
Has all that been at Van Zandt County?
No, Judge. Part of that time was in TDC, and part of it was in
ISFN.
ISF.
Okay. I'm not able to enter in the credit time on the judgment, so that will need to be fixed. So we'll go ahead and continue the plea. But Mr. Hartwell, if you can ask Ms. Abney or whoever's preparing paperwork today to resubmit so that Mr. Manning and Mr. Matthysse can sign again, or if they could just, well, I think they're going to have to do that. She's going to have to do that. The time credit field was not in there, so I'm not, either she can enter it manually and send it back to us, or she's going to have to put the field in there that will allow me to enter it.
Yes.
All right, so Mr. Matthysse, you would receive jail time credit of 1,293 days towards your sentence. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Sir.
All right, Mr. Matthysse, understanding the plea agreement and the range of punishment, how do you plead to tampering or fabricating with physical evidence?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Mr. Matthysse, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection as offered.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
That's close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court convicts the defendant of the third-degree felony offense of tampering or fabricating physical evidence. The court assesses punishment pursuant to the plea agreement at 4 years confinement in prison. The court orders him to pay a $1,500 fine, $180 in restitution, $290 in court costs, and $15 in reimbursement fees. The court dismisses under section 1245, cause number CR 19183, possession of controlled substance, and the court awards Mr. Mathis jail credit towards his sentence in the amount of 1,293 days. Mr. Mathis, once you're released from TDC, you'll need to come to the courthouse to pay your fines, restitution, court costs, reimbursement fees, if you haven't paid them off while you're in prison. If you're not able to pay all those off at one time when you're released, then come to the district clerk's office and request a payment plan. Failure to do so could result in the court issuing a warrant for your failure to pay those financial obligations. Do you understand?
Yes, sir.
All right, so Mr. Mathis, what we're going to do is I'm going to have you step over to be fingerprinted, and then you're going to have to re-sign your paperwork in just a moment, okay?
All right.
All right. All right, Mr. Manning, I'll be looking for that. As soon as I see that, then I'll just hop in there and sign it.
Yes, Judge, and I will make sure to get an order over on Mr. Hughes as soon as I get back to the office.
All right, thank you, sir.
Thank you, Judge. May be excused.
Yeah, but you're going to stay there and sign with Mr. Mathis. Is that correct?
That is correct, Judge.
Okay, yes. Mr. Abraham, do we have anything further?
No, Your Honor.
All right, if there's nothing further, then the court, having completed its docket, is adjourned. Thank you all for your work.
Thank you, Your Honor.
You're welcome, sir. Mr. Hartwell, Mr. Hartwell, you still there?